The last future interest is actually one we've seen before. An executory interest is a future interest created in a transferee that becomes possessory, if it does at all, by way of divesting or cutting short the preceding vested interest or estate. Divesting is the defining characteristic of executory interests. We first encountered executory interest when we studied defeasible fees. Recall that if a grantor simultaneously conveys a fee simple and a future interest following it, that future interest must be an executory interest. A remainder can never follow a fee simple because remainders must be capable of taking effect upon the natural termination of the preceding interest or estate, and fees simple may last forever. For example, suppose O conveys land, quote, to A and her heirs, but if A ever drinks alcohol on the land, then to B and her heirs. A has a fee simple subject to executory limitation. It is subject to being divested by B's executory interest if A ever drinks alcohol on the conveyed land. As future interests go, the executory interest is the Johnny-come-lately of the bunch. To see how executory interests came about, we have to trace a bit of English legal history. In feudal England, there was only one legal future interest that could be created in a grantee, and that was a remainder. Specifically, the common law courts did not recognize any future interest in a grantee that could cut short a vested interest or estate immediately preceding it. In other words, the common law court did not recognize what O did in the example just given. What the common law courts refused to do, courts of equity went ahead and did. Feudal lawyers developed a clever arrangement known as a use. O, going off to fight a crusade, would convey land to the possession of, say, his brother for the use of O's wife and children. The common law courts would not enforce the use, recognizing only the conveyance to the brother. But Chancery, the court of equity, did. O's brother held legal title, but in equity, O's wife and children had the beneficial interests which Chancery would enforce. In truth, this was a big tax dodge. Because the beneficiaries of the use did not hold legal title, they were not obligated to pay feudal incidents to the lord. The arrangement was so advantageous that by the 16th century, a large portion of all land in England was held in use. The situation was unacceptable to the king, Henry VIII, who needed the feudal incidents, which were the equivalent of taxes. In 1536, he pushed through Parliament an important piece of legislation, the Statute of Uses, which got rid of uses by converting them into legal estates that would be subject to all the usual feudal incidents. So, for example, suppose O conveys, quote, to X and his heirs for the use of A, who is O's eldest son, and his heirs. But if A inherits the family manor, then to the use of B, who is O's second son, and his heirs. After 1536, the statute executed the use and turned A's and B's uses into legal interests. As this example shows, the statute of uses has the effect of recognizing a new legal interest, the executory interest. After the statute, A had a defeasible fee and B had an executory interest. By the way, just as a quick refresher of earlier material, which type of defeasible fee does A have? Is it A, a fee simple determinable, B, a fee simple subject to condition subsequent, or C, a fee simple subject to executory limitation? If you said C, give yourself a gold star. One other effect of the statute of uses was to recognize a new type of defeasible fee, the fee simple subject to executory limitation. Let's do a deeper dive into modern executory interests. It's traditional to distinguish between two categories of executory interests: the shifting executory interest and the springing executory interest. There is no practical difference between these two categories. Nothing of any legal consequence turns on the distinction. It is useful simply as a way of identifying the person whose estate or interest is divested. A shifting executory interest is one which divests an interest in another grantee. Suppose O conveys land, quote, to A and his heirs, but if A inherits X's estate, then to B and her heirs. B has a shifting executory interest because if it becomes possessory, it would divest the estate held by A, another grantee. More commonly, shifting executory interests follow vested remainders. For example, suppose O's will devises, quote, to A for life, then to B and her heirs, but if B does not survive A, then to C and her heirs. C has a shifting executory interest because it takes effect, if it does so, by way of divesting B's vested remainder. A springing executory interest is one which divests the grantee. For example, suppose O conveys, quote, to A and her heirs to take effect in possession and enjoyment upon A's marriage. Here, O retains a possessory fee simple, which will be divested by A's executory interest only if and when A marries. In some cases, the grantee's interest that is subject to being divested is not as apparent. Take this case, for example. O conveys, quote, to A for life, then upon the completion of the administration of A's estate, to B and her heirs, if B is then alive. There will inevitably be a time gap between A's death and the completion of the administration of A's estate. We don't know how long it will take to administer A's estate. It could be a few months, or it could take years, but it is certain that it will take some period of time. During that time interval, B is not yet entitled to take possession. So who has the right of possession? The answer, of course, is O, who now has a possessory fee simple subject to being divested by B's executory interest if and when B survives the administration of A's estate. One situation in which it may be difficult to determine whether a future interest given to a grantee is a remainder or an executory interest is where more than one future interest follows a life estate or a term of years. For example, consider an example we looked at earlier, where O's will devised, quote, to A for life, then to B and her heirs, but if B does not survive A, then to C and her heirs. We said that C has an executory interest. But now change the language just slightly so that it reads to A for life, then to B and her heirs if B survives A. Otherwise, to C and her heirs. Now what does C have? A contingent remainder. B, an executory interest. As you probably guessed, the answer is A contingent remainder. But do you know why? The reason is that the preceding interest is not vested. It is a contingent remainder. So the succeeding interest cannot be an executory interest because the executory interest divests. And obviously, they cannot divest interests that are not vested. Two easy shortcut rules follow from this. First, if you have a life estate followed by a contingent remainder in a fee simple, with a second future interest given to a grantee, that second future interest must be a contingent remainder. Second, if you have a life estate followed by a vested remainder in a fee simple, with a second future interest given to a grantee, that second future interest must be an executory interest. Considering that it isn't always easy to distinguish between contingent remainders and executory interest, you might well ask whether this distinction really matters. The answer is yes and no. At common law, there were important consequences. Certain legal rules applied to contingent remainders, but did not apply to executory interest. Notably, the rule of destructibility of contingent remainders did not apply to executory interests. The rule in Shelley's case. But both of these rules have been abolished in all but a small number of jurisdictions. So, for all practical purposes, except in these jurisdictions, there may be no legal consequences to the distinction. In fact, in some states, there are statutes that include executory interest in an all-inclusive definition of a remainder.